Awesome. Yes, we're live. Fantastic. Good stuff. So welcome to another conversation with on business foundations. And today I'm delighted to have some of Louise Hall's time. She is a solicitor and helps businesses with all things legal. So I wanted to talk to Louise specifically about what companies should be doing and what they're probably not. But before we get into that, Louise, do you want to give us a sort of overview of the main work you get involved in?
Yeah, absolutely. So first of all, I just need to check and clarify, although I am a solicitor in my own right, I'm not practicing as a solicitor in my business. So my business is 2020 Business Law, and it's set up as a consultancy rather than as a firm of solicitors. So I don't hold myself out as being a solicitor in my business.
Okay.
What it means in effect is that I have lower overheads, which means that I can work slightly more flexibly than a firm of solicitors may do. But in terms of the work that I do, I work exclusively with business owners, and I start at the beginning of the journey. So if you need help setting up a business and getting all of your sort of key building blocks in place, then we start there. Yep. Then through basically the life cycle of the business. So things like contracts, things like all the legal things you might need when you're growing and running the business. And then at the other end, selling the business or franchising it, or closing down the business. It's sort of the cradle to grave approach.
Okay. And it would probably be fair to, I know we were talking just before we came on air, I would suspect a lot of people out there and a lot of businesses have a kind of either an uneducated, I don't mean that in a mean way, but in a kind of, they really don't know what they should be doing. And law is probably one of those topics, like a number of other things, where it's all a bit complex. So they tend to take the approach of, we just won't do anything.
Yes, I have had that with clients. They sort of bury their head in the sand a bit. And you know what, that's what I'm here for. That the whole, I wouldn't be in business if people knew what they were doing. But although it's not tax, law doesn't have to be taxing. And I think once you've got your main building blocks in place, then chances are, you can carry on and not have any issues for a good while.
Okay, and I think there's a key point, which I know Lizette last week when we were talking about very specifics around sort of data protection, a line she used, which applies very much to your field, is a lot of people will just say, oh, I don't know about that, so that's okay, I don't need to do about it. And her line was, ignorance of the law isn't a defence against it.
Absolutely, yeah.
And I suspect there's a lot of us out there, especially in business, where we don't know what we should be doing.
Yeah.
And we're probably leaving ourselves open to kind of issues, which, as you said, obviously at the point you hit big issues, if lawyers are involved at that point, it tends to, one, get quite ugly, and two, quite expensive very quickly.
Yeah, absolutely. It's always better to prevent rather than cure. But I think, yeah, it's very true. You don't know what you don't know, do you? But then I think this is why your group is really good, because we're able to reach out to people and say, okay, the things you need to think about are this, 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 and this. Mm-hmm. Some other things are, yeah, they're nice to have, but they're not essential. But always, I would say it's better to have something in place at the beginning than to try and deal with it afterwards. So, for example, if you don't have terms and conditions or a contract with your clients, mm-hmm. if things go wrong, then you're sort of falling back on what is implied by law, and
right.
Actually that's not necessarily a satisfactory place to be.
Okay. And it's not necessarily satisfactory for you in that situation, is it? You might think, oh, legally I'm fine, but actually it doesn't.
Yeah, exactly. And the thing is, your terms and conditions and your contracts don't have to be excessively detailed or complex. They can be, one side of A4 if that's what you want.
Yeah.
It's just really important to set the scene for how the relationship is going to work.
Right.
So that everyone knows where they stand. And if there's any disputes, then you can refer back to the contract and say, well, look, this is what applied between us. Mm-hmm. And normally that will help to resolve some disputes.
Yeah. Okay. So we talked about cradle to grave, and I'd really like to sort of pick on a few of those bits in a minute. But I suspect two of the biggest areas where people will really get value from today's session is around what you need on your website. So some of the stuff around there. So it'd be good to touch on that. But also, you've already kind of sort of hinted at it, the whole what you need from a contract basis with your clients. So if we kind of touch on those two, so if we go to the website to start with,
Yeah.
most of us have websites out there. And again, there's a number of bits and pieces legally you should have on there. So do you want to quickly run through what they are and what people should have on there?
Yeah, absolutely. So I mean, you've already spoken to Lizette last week, and so obviously there's all the data protection stuff that really needs to be on there. But from a legal point of view, you would need to make sure that you've got your identity on there. And by that I mean if you're a limited company, for example, you'd have to have the company name, company number, and the address. And then sometimes you can have a terms of use which might put things along the lines of we don't guarantee our website's going to be up, although we'll do our best to keep it updated. You know, we can't guarantee it. You might say we might link to other websites, but we don't endorse or recommend them, because obviously if there's something wrong on their website, you don't want to be liable for that.
Yeah.
But more importantly, I think, is especially if it's a website where you're selling through the website, that's when you really need terms and conditions on the website.
Okay.
Because if you don't, and someone places an order with you, unfortunately, at the point that the order's placed, that's when the contract is formed. So if you later try and send your terms and conditions, by that point it's too late and your terms and conditions won't apply. So if you're selling online especially, that's when you need to think about it. And I think with the whole COVID-19 thing, and people are sort of flipping the way they work and changing to do different things, selling online, I've got a client, for example, who was a bricks and mortar shop, and they now have a website.
Yeah.
And that's how they're going to be working, because although they can reopen now, actually this is been a lifesaver for them, really.
Right.
And for those kinds of businesses, if you're selling online, you really do need to make sure you've got something there. And it depends as well if you're dealing with consumers or with businesses. So if you're selling to consumers, then there are some certain things that can't be avoided in terms of consumer law. If you're dealing with businesses, it's a bit more flexible.
Okay. And just on terms and conditions, so it's an interesting point, which I wasn't aware of, that if you're selling it, it's the terms and conditions that are available at the point of sale. It's not, you can't send it to them afterwards and say, these are our terms and conditions. No,
and that's the thing. I've with all of my clients, if I help them with their terms and conditions, I'll say to them, where are these going to be used?
Yeah.
Because a couple of years ago, I had a client that had some fantastic terms and conditions prepared by a big, City of London firm.
Yeah.
And that was fine, but they sent it out with their invoices, and that's too late because the work's already been done at that point.
Right.
And it needs to be, for terms to apply, it has to be incorporated into the contract. So it has to be there at the point that the contract's formed.
Okay, so we're kind of, there's two bits, and I'm kind of getting a number of questions in my head on this. So on it, assuming that someone's not selling online, that they're just selling services or goods, but it's not online, they still need terms and conditions?
I'd say it would be a good idea to have them online.
Okay.
And the reason for that is that if you're sending emails, for example, to these people, your clients, you can always put a link saying our terms and conditions are found at, and then have a hyperlink to the terms and conditions on the website.
Yeah.
But also, you might want to have, for example, for me, I offer legal services. I might want to have a disclaimer on my website saying, if I write a blog about X, it's for information, but it's not advice tailored to you. So I guess things with, whether you're an accountant, an architect, IT company, anything like that, if you've got blogs and things like that up, what you want to do is just to say, look, this is just for information. It's not, legally binding advice.
Yeah, okay, that's really useful. So actually, it would be kind of your recommendation. I appreciate we're not giving specific recommendations, but it would be better to have your terms and conditions on your website, even if and then just refer to them.
Yeah, I mean, as long as to be incorporated, they have to be brought to the attention of the customer at the point that they place an order.
Okay.
I wouldn't just rely on them being on your website. You'd have to specifically refer to them to make sure that they're brought to their attention.
You'd have to explicitly say, our terms and, in signing this, you are agreeing to our terms and conditions, and they can be found at blah,
yeah,
our website.
Absolutely, yeah.
Okay, so I think that's useful. The other bit which is kind of came in my head is that obviously people change their terms and conditions at times. Now, I think I know the answer to this now based on what you've told me, but if you change your terms and conditions, that's only going to apply to people going forward, isn't it? It doesn't retrospectively apply.
No. So if you've already got a contract in place, the new terms and conditions would only apply if the other parties say they agree to those applying.
Okay.
Otherwise, you've already formed your contract.
Okay, and if it's a contract, an ongoing, if it's a kind of recurring contract over a period of time, again, it's at the point the contract's initially executed, rather than if it's say a monthly service.
Yeah, so this will depend on what your terms and conditions say, because you could put something in your original set of terms and conditions and every revision that we reserve the right to update our terms and conditions. So refer back to this page. This is why having them on the website is a really good idea.
Yeah.
Refer here for our up-to-date current terms and conditions, because all sorts of things might change. You might find that prices change. So we know VAT, for example, if you're providing accommodation, the VAT rate is going to drop from 20 to 5%. Your cost of materials might change. I know a lot of my clients that are builders, for example, plaster, bags of plaster, normally £6, currently £30. All those sorts of things, you need to be able to control your pricing, because otherwise, if you've given someone a fixed price and you don't have terms and conditions in place, then you're stuck.
Right. Okay. And so I think, from just to play back what you said, you can, if you put a clause in your terms and conditions that basically say we can change these, that would apply effectively to a retrospective thing as well, or am I missing the point on that one?
So no, it will apply, but it will apply from the date that you change the terms and conditions. Right, so if you've got an ongoing contract at the beginning, they've got one set of terms and conditions. Month 3, they're different versions of terms and conditions. Then from that point onwards, that's when the new terms and conditions will apply. Got you.
Okay, so that kind of raises another one for me of, if you do change the terms and conditions, you need to keep the old versions as well.
Yes, you should keep a version for your own records, but obviously not on your website. You want to update those ones.
Yeah. Okay, but you need to keep that version so that at least if there's any issues, you can refer back and sort of go.
Absolutely.
Okay, that's good. I think I understand that now. So the other bit, and this is one that I know a lot of people will not have in place, or probably not, if they do have, not necessarily great ones, is the whole having some form of contract with a customer. So talk me through the kind of essentials of that, and kind of why it's so important, because I suspect a lot of people out there won't have these.
Yeah, so in terms of a contract, if you have terms and conditions, you can always, the contract can be very, very basic and say, this is a contract between, and name the two parties. And when I'm just backtracking a little bit, when you work with a new client, make sure you know exactly who they are. So if it's a limited company, make sure it's the limited company that you've named in the contract.
Yeah.
Or if it's an individual, make sure you've got all their contact details and things like that. Just because if you need to call on it, it's that idea. So if you've got terms and conditions, your contract can simply say, we will do X, Y, Z, our terms and conditions apply. Otherwise, if you want it in a formal contract, you can do that as well. And the terms and conditions would just be sort of the filling in the sandwich, really, between the party names and the signature block at the end. Okay. And the good thing about having a contract that's signed, or somewhere where someone can tick a box to say that they agree your terms and conditions, because that's as good as a signature.
Okay.
That just prevents there being any dispute that they saw the terms and conditions when they entered into a contract with you.
Okay. So having some sort of fairly clear statement of this and then referring to terms and conditions is kind of an essential part, really, from what you're saying.
Yeah, absolutely.
Okay. And in this kind of day and age of, obviously, we well, especially even more so at the moment, because we're not really seeing anyone, is it all things like electronic signatures, emails, does that count? I mean, there's I know
absolutely
where they've said, oh, I sent it an email, but it doesn't count, it's not legally binding.
No, if it's in writing and you've sent it to someone, and even if they don't reply to that email telling you to proceed, if they perhaps verbally say, yeah, go ahead, then just because they haven't written to say, yes, please go ahead, if you've then provided the services at their request, and they haven't told you not to, then as long as you can show that they understood that your terms and conditions applied, they can't really escape by saying, well, I didn't sign them.
Okay.
And so, for example, you don't need someone to physically have a wet ink signature on some terms and conditions. Right. If you say, please reply to this email if you want me to proceed, and they then reply, then that's fine.
Yeah. Okay. And I think that's important to understand as well, because sometimes people go, oh, I need a kind of war and peace document signed by the client, and that's not the case, is it? No. It's whilst I know some aspects of law can be quite heavy, a lot of the stuff that you're probably dealing with here is quite simple.
I mean, there are some things that you can't sign electronically, but they're few and far between. Things like wills, for example, have to be proper handwritten signatures. Okay. But for general commercial stuff, you're fine.
Okay. So coming back to the kind of cradle to grave stuff, probably a few bits I want to kind of touch in on a business. So the startup, what are the key bits? I suspect there will probably be a lot of people at the moment who are either sitting in an employed role or sitting at home having been furloughed, and they're kind of expecting they're coming back to being told, actually, you're not required here anymore, or it might have just pushed them over the edge. And I've got a number of people I'm speaking to at the moment who have been looking at setting up their business for years, and this has finally been I'm going to do it now. What are the key bits you have to have in place when you first start a business from a legal perspective?
Yeah, so before you start the business, if you've been employed, I would make sure you check your contract of employment just to check that there are no restrictions in there. So if you've been working for, I'm going to take this as an example, a plumber, and you go and set up in competition, if there are restrictions in your contract and they are binding, sometimes they're not if they're too wide, then you need to be careful that you're not going to be on the hook for any claims there. But yeah, once you're ready to start your business, the key things are to think about the right vehicle to use, whether you're going to be a sole trader, whether you're going to be a limited company, if you're going to work with others and be a partnership. That's sort of a key thing to think about, and probably talking to your accountant would be the best step to work out what's going to be more tax efficient for you. Okay. The good thing is that, for example, with a limited company, it might not be the right vehicle for everyone, but you do have the element of protection. So limited liability means that if something happened and the company got sued, you should have insurance anyway. But if you don't have insurance, then if the company gets sued, that stops with the company. Right. And as a director, you wouldn't be personally liable unless there were things like fraud or some things like that. But with a sole trader, it's very different. The sole trader, it is you personally that's on the hook for things. Right. Okay. Having said that, sometimes sole traders it's more cost effective and tax efficient to be a sole trader. So there's lots of things to weigh up there. Right. Once you've decided on how you're going to go forward. So if, for example, you're going to go into partnership with someone, make sure you've got a partnership agreement that sets out exactly who's brought what. Sorry, my lights have just gone off.
That's one of the most
who has brought what into the business, what your respective responsibilities are, what happens if one of you wants to leave, if one of you becomes insolvent, something like that. It sort of sets the scene for the relationship. And similarly with a limited company, if there are going to be different shareholders, you might have different objectives and different goals later on, so you want to make sure you've got a shareholders agreement in place. And again, they don't need to be complicated. They really don't.
Okay, so both of those are points where that's a startup, but you could have that at any point in the business life.
Absolutely, yeah. So if you bring in someone later on, yeah, absolutely, absolutely. And probably especially if you're a sole trader, you might want to get a business LPA as well. That's lasting power of attorney. And what that means is if you lose capacity, it appoints someone else that can run the business until you're back on your feet again. Otherwise, if you go, then the business is gone. So it's just sort of protection there. And then once you start trading, that's when you start looking at your terms and conditions and things like that. But I would say the key document you can have as a business is a set of terms and conditions.
Right. Okay. So then moving through the kind of life cycle of the business, obviously, well, there's two parts. Right? You sort of said cradle to grave. The first bit is on actually of sale of a business. So let's assume a business is being sold. I'm assuming that there's some advice you could probably, if a business is thinking about it, it's probably some advice you could give them before they go into the sale process around what they should have in place, what they should do.
Yeah, so if they're looking to sell their business, obviously it's going to be more attractive to a buyer if they have all of their paperwork in place. So if they've got terms and conditions in place, and in moving towards the sale, the first step in any sale will be answering questions that the buyer may have about your business. So due diligence. So at a very early stage, if you're going to be looking at selling the business, make sure you've got all your paperwork in order so you know where everything is. So questions will come in about insurance. What insurance policies do you have? Right, here are all my documents. Accounts, can I have sets of your accounts? Right, here are all my accounts. Employment contracts, all those sorts of things. If you have them all to hand ready, it means that it's going to be a lot less painful when it comes to selling the business. And the other thing is, if you're starting to talk about selling your business to someone else, you might want a non-disclosure agreement or a confidentiality agreement, just to make sure that whatever you're disclosing to them is only used for the purpose of assessing the business, rather than for them, you don't want a competitor, for example, to see all of your client lists and then to go and pinch them.
And in fact, an NDA is something that could be relevant earlier in the life cycle as well, if you're bringing.
Oh yeah, absolutely, absolutely.
Okay, and then on the actual the sale agreement, I'm assuming that's going to be some form of legal document as well.
Yeah, and it depends on the type of sale as well. So if you're a sole trader, all you can do is an asset sale because you don't have a limited company with shares. If you're a limited company, you can have an asset sale. Where you sell all of the assets of the business, the goodwill, transfer the employees, that sort of things. Or you can sell the shares, in which case the whole business, it just transfers to the next purchaser. So the two different options, and again, that really is driven by what's more tax efficient and what the buyer wants, because you may not have a lot of choice. If the buyer just wants an asset purchase, because then they can cherry pick what they want and what they don't want, you might not be able to push for a share sale. Whereas a seller will want a share sale, because as soon as someone takes over the shares, they're liable for the company, and any debts transfer with the company.
And you touched on a point which I was going to ask anyway, is obviously, and this is where you need to be quite careful when you're selling a business, is if they don't take the shares, they're not taking any liability. So I've seen scenarios where someone, in their mind, they've sold their business, but actually they've just sold all the assets. and they're left with no income and a fairly
Yeah.
hefty debt because there was a liability within the company, and they're like, oh, that's that person's matter. Well, no, you're the shareholders, it's your liability.
Yeah, absolutely. Well, it is your liability, but only as far as, because it's limited by shares. Say you've got £10 shares,
Yeah,
and your liability is limited to £10,
right,
unless they can show that the asset sale was designed to defraud creditors.
right, okay. So there's a number of bits, which is really making sure that we're involving someone like yourself at that point's a good idea, because there's a whole kind of
Absolutely,
worms
yeah,
open up at that point.
definitely.
Okay, so the other bit, which obviously does have massive financial implications, and I think needs to be legally kind of set up properly, is what happens in the event of a business owner dying. Now, obviously, there's the kind of tax treatment and all that sort of stuff, but actually, it's having, and I can remember back to days when I used to run some software company, we had fairly detailed shareholder agreements around what happened, and there was almost an order of who got first dibs on making an offer on the sale, and what that meant, and if it could be rejected. There was all sorts of things around there to determine who actually got what in the company.
Yeah. So yeah, absolutely. So if you're a partnership or a limited company, that's when you need the partnership agreement or the shareholders agreement that specifically sets out what happens when. The other thing is that if you are a sole shareholder, sole director, you need to have something in your will to make sure that your business can carry on,
Right.
and then be sold.
Yeah.
Likewise, if you're a sole trader,
Yeah.
because otherwise suddenly there's no one to run the business, and it goes. And it might be that you've got some real value in the business and you want to be able to leave it to someone. But if you do have a shareholders agreement, because you've got more than one shareholder, that can set out all sorts of eventualities that might be important to you. So I had a family business that I was helping, and they wanted to have they wanted their children to basically inherit, rather than risk the spouse who knows nothing about the business because they haven't been working in the business.
Right.
Rather than them getting the shares, they wanted to make sure the children got it.
Right.
And protect all of the interests to make sure that it stayed within the family. And that's when the shareholders agreement really would be important.
Okay.
But also it might cover things like if someone's a bad leaver, which might mean someone that is basically been ousted from the business, you might want to pay them less for their shares than if they're someone that just wants to sell and move on or retire. And you can make provision for that in the shareholders agreement.
Okay.
I mean, there's lots of different options that you can use, and I start with a questionnaire that sort of sets out what the different options are, what are your concerns, because every business is different, they've got different dynamics, and the shareholders will have different concerns.
Well, I think also it's one of those things, much like any relationship, when you go into it, so starting a business or starting, you don't have the, okay, what's going to happen if you die or you annoy, you kind of fall out. You almost don't want to think about that, because like we're being positive, but you really need, that's the point where you really need to go, look, let's lay out exactly what happens so that if that does become an eventuality, whilst it'll be rubbish, at least we've got an agreed kind of approach that we agreed on when we were.
And the really important thing to remember is that it might cost you a few £100s now to have a shareholders agreement. If you leave it,
it could cost you a business.
It could cost you a business. And if you fight it and try to deal with it at that point, legal fees could be thousands of pounds. So that way, at least if you've got the shareholders agreement at the beginning, you know exactly where you stand. And if things change, so you bring other shareholders, you can say, right, any new shareholders, you have to sign it's called a deed of adherence.
Mm-hmm.
So it means that you're bound by the shareholders agreement as well.
Yeah.
Or you can amend and change the shareholders agreement as you go along.
Right.
But it's important, especially with businesses that are planning to grow. If you've got initial shareholders, you want them to have perhaps extra power than shareholders that might come in at a later date.
Okay, so you can structure it so that they have different rights effectively within the setup.
Yeah, and it doesn't. The thing with shareholders agreements is people do think they're scary because they deal with really big issues, but actually once they're done, that's that weight off your mind that you don't need to think about it because you know it's all been agreed. And you're sort of preempting what possible disputes might come up. And by dealing with it now, it stops them happening in the future.
Absolutely. Okay, I think that's really useful. So there's a couple of other points that just kind of come into my mind as we've been talking through. So, and they're similar, but they are different. So around copyright and trademarking.
Mm-hmm.
So again, people have different views on this, but it'd be really nice, really interesting to get your legal view on, certainly on trademarking. So a number of people I speak to, they say, I'm going to trademark my company name and stuff like that. I have an opinion on that, but it's not necessarily particularly positive. But what's the kind of legal view on that as to should you, shouldn't you? I mean, I get the point of why you do it, but what's your opinion on that one?
I think it depends completely on the business. There are certain things you can't get a registered trademark for anyway. So if the name's not distinctive enough, or I mean, there's lots of other different restrictions, but that's the key one. If it's not distinctive enough, even if you apply for a trademark, you won't get it. It does give you an element of protection, and on its own, a registered trademark is an asset which has value, but it's not necessary. If you've been trading using the same name, then something can apply which is called passing off, which means even if you don't have a registered trademark, if someone starts using your business name, you can say, well, hang on, we've got the goodwill in this name, you're using it, stop. Obviously having a trademark is more robust, but especially with businesses rebranding, it may be that you don't need a trademark. But I would say each case is different, and it just depends on what you want to secure. And also the other thing is, if you've got a logo or a business name, is it the logo you want to protect, or is it the name?
Right.
And in terms of the trademark, if you were to, I've got lots of different things floating around. So if for example, you were to franchise your business, and your business was called ABC, and you have a registered trademark for ABC, that's going to be more attractive to someone that wants a franchise of your business than someone who's called ABC and doesn't have a trademark, because it's a little bit harder to fight if you don't have a registered trademark. But they're not for everyone, and you may not need them. And if you've got a company name registered at Companies House, so although my business name, the trading name is 2020 Business Law, my Companies House name is Irvine Hall Limited. I know that no one else can have that company name because you can't have one that's exactly. Turning to copyright is automatically arises anyway. So if you've written something, you automatically have copyright. You don't need to register anything for that.
I think my question there was more around making sure you don't breach other people's copyright, and it's something that I know, especially with social media, is very easy to do.
Yes, absolutely. So just be extra cautious. And if, for example, you are having, so if you have an employee that produces a document for you, because they're an employee doing it in the course of their business, your business, course of their employment in your business,
Yeah.
The business owns the copyright. If you get a third party to take some photographs or produce your website, anything like that, it will depend on what's in their terms and conditions as to who has that copyright, because if it's silent on the point, they own it. And so you might find that actually, although they've produced some amazing content for you on your website, because they've got the copyright, you can't cut and paste that text and use it elsewhere unless they've assigned it to you or they've given you a license to use it.
Okay. So, I mean, a great example, and it kind of prompted because we had this conversation before we went on air this morning. If we take this Facebook Live, that's obviously a recording, effectively that's my copyright.
Yeah, absolutely. So, well, because we're both on it, it's a bit tricky. But no, I would say because you have set it up, we jointly have copyright because I'm also contributing.
Brilliant.
However, as far as I'm concerned, you know, I'm happy for people to share it if people think that it's useful and beneficial to them.
We had at the beginning, and obviously when I email you the link, I've also put some terms to go. I'm quite happy for you to use all this.
Absolutely. The thing is, it's all about raising awareness for business owners. We're all in this together. I'm a small business owner myself, 2020 business law. You know, I don't have offices here, there and everywhere. I've got 2 offices, you know, a small team of people. I'm here to help other people. So if people want to use the material or the advice, I will just go and put a disclaimer saying this isn't bespoke to all businesses. So you may want to seek independent legal advice. However, I'm always happy to have a chat.
Absolutely. And I think that's the thing, but I know a number of people have come across or can run into issues with copyright where they just assume they can use something and they can't. So it's just being quite cautious with that, isn't it? And
if in doubt, just ask.
Yeah, absolutely. Good stuff. Okay, well, I think we've touched on a number of topics today, and I've been watching, there's a few people who sort of come in live, and it's the sort of topic where I wasn't really expecting any questions. I suspect lots of people will have questions, but they'll probably they're possibly a little bit scared to ask them right now, or they're not totally sure. So I suspect we'll get some questions kind of coming in later in the thing, which is fine, because obviously people will watch this after the event as well. So are there any bits we haven't touched on today that you think so businesses should be aware of or should be thinking of, either in general or specific to obviously all the kind of situation at the moment with all the lockdown and coming out of that?
Yeah, so I guess different things to think about, given things aren't quite back to normal yet, are things like making it clear in your terms and conditions that time isn't of the essence. So if you've got a deadline to deliver things, make it clear that, you know, sometimes things happen that are outside of your control. So going back to the thing about the plaster for a builder, if you can't source materials, then that's going to delay things. So I would just, you know, make it clear in any contract or terms and conditions that although you'll do your best to deliver to fixed dates, unless that it's explicitly agreed that that will happen, that, you know, something major crops up that stops it from happening, you're not going to be liable. The other thing is, if you're, I guess, dealing with consumers, whereas just picking up on the example from the lady that ran her own shop and now has a website, if you're dealing with consumers, there are certain consumer rights that you can't exclude. So, for example, the goods will always have to be fit for purpose, satisfactory quality. There's a 14-day cooling off period if you buy things as a consumer online from the date that the goods are delivered, not from the date the order was placed.
Okay.
And you can't refuse refunds for that period.
So certain things around consumer law that effectively, even if you put in your terms and conditions, this is what we do, that's irrelevant because consumer law effectively overwrites that.
Yes, absolutely. But there's a really good sort of summary on the WHICH, so WHICH website. They've got a consumer rights section there about consumer law. And if any businesses do supply services to consumers, I'd recommend having a look on there just to make sure you understand what you have to do.
Okay.
And also limitation of liability if you're dealing with consumers.
Yeah.
It's more restrictive. You can only restrict liability if it's reasonable.
Right. Okay. Cool. Okay.
So there's lots and lots and lots and lots of things to think about. But as I said earlier on, I'm always happy to chat. So if anyone's got any questions and they want to drop me an email or just give me a call, I'm very happy to have a chat. No problem.
Okay. And I think that's one of the things. It's probably a topic that it is big and people are just scared. And I think a lot of people's experience of any kind of interaction with solicitors is it's very expensive very quickly. And lots of solicitors, although actually a number now I know are happy to have that initial conversation, a lot aren't, and there's kind of the clock's ticking as soon as you go through the door. So actually having
but that's part of the reason I set up the way that I did. As a solicitor working for other firms, I absolutely hated recording my life in 6-minute units. So now I say to clients, have a chat with me free of charge. If I do work for you, then I will charge you. And I give them a fixed fee, so they know exactly how much it's going to cost. And one of the guarantees, sorry, the lights are off again. One of the guarantees I give is that there will never be an unexpected bill, because we'll agree everything in advance before we do it.
Brilliant.
And I would say, if you're serious about your business and you're serious in investing in your business, then do the groundwork now so that you don't have to deal with fallout later on. You might be very, very lucky and never have a dispute. But if you do, it's not just going to cost you money. It's going to be stressful. It's going to take time away from focusing on your business, and it's just not worth it.
Absolutely. Okay. One bit which we explicitly haven't touched on today, which obviously has legal implications, is the whole HR aspect. And actually, from conversation with you before this, was that's the whole subject in itself. And obviously, I've got a session with Sam next week, I think, about.
Yeah, Sam's fantastic. We work very closely together.
So it's one of those things where people are watching today and thinking, well, hang on, there's a fairly big aspect to law you just haven't touched.
Yeah, no, definitely. It's
obviously at any stage on kind of employment contracts, tutoring, if you're selling businesses, all sorts of things, which are massive, but obviously we'll you hand off to someone who's much more specialist on that one when that.
Absolutely. Well, and the good thing with an HR specialist like Sam is that they don't just do sort of the legal documents, they do all of the soft stuff in between, dealing with difficult conversations with employees and things like that. So get a good HR person on side and you'll be made for life. Fantastic.
And if people haven't met Sam, you'll meet her in my session with her next week. She's certainly a real
firecracker.
Yeah, real character, and I mean that in a positive way.
Yeah.
So, I'm not being.
And she's just had her hair done, so you're in for a treat.
I had a chat to her yesterday, and it's looking particularly purple at the moment, which is good. Fantastic, good stuff.
I'm getting my hair cut next week. I'm definitely not having it coloured, but it definitely needs a good cut.
Yeah, it's amazing what sort of conversations change that most of the kind of women I've been talking to. I've done my hair, or I've got it booked in next week.
I've never been so excited about anything in my life. I'm not even a girly girl particularly, but I'm really looking forward to having a haircut. Simple things.
Yeah, absolutely. Well, thank you for today. That has been really useful. I really appreciate your time. And
no, thank you.
What I will do is I'll put your contact details below in this as well. So if people have got questions specific, they can either post in the group, and I'm sure Louise will answer them. But I'll put Louise's contact details as well. So if you do have any questions, just get hold of her. She's more than happy to have that initiative.
Absolutely.
So that's brilliant. So excellent.
Thank you very much for having me.
Good stuff. Right.